Welcome to the 6th episode of our talk show here on Advocates Philippines. My name is Paulo Capino, your host and the Chief Executive Officer of Advocates Philippines. We have our special guest, Attorney Renel Rodriguez.
Thank you for having me here, Paolo.
I asked for Attorney Rodriguez's help because here at Advocates Philippines, we received summons that was published by the Philippine Daily Inquirer, and it describes about a case between Primary Land Holdings and Philippine Primark Properties versus Premier Town Center Holdings Inc. and SM Investments Corporation and Corporate Investments Limited. Before we go to the meat of the published summons on the Inquirer, Attorney Rodriguez, can you define to us what is the difference between a summons and a complaint?
The complaint is a document that is initiatory pleading. It is filed by a plaintiff. A plaintiff is a party who has a claim against the defendant, civil action. The complaint contains all the allegations about the controversy at hand and what are the reliefs they are asking. On the other hand, summons by publication is a document issued by the court, informs the defendants that there is a complaint against them, and then they are given a certain period of time to file an answer. Summons by publication is issued whenever a defendant cannot be located by ordinary means, by personal service, or for example, if a defendant is out of the country. And the purpose of a summons is for the court to acquire jurisdiction over the defendants. If the court doesn't acquire jurisdiction over the defendants, then any decision rendered by it will not be binding on the defendants. So that's why it is important for the defendants to receive summons.
So we also received the summons here on Advocates Philippines, and for full disclosure, we also published it as requested by Primark, and it was also published on the Philippine Daily Inquirer, I think a week after. So this means, just to clarify for our viewers, the summons was issued by the court and not the complainant.
Yes, it is a document coming from the court which requires the defendants who were mentioned therein to file an answer or a response to the complaint.
So, based on what I read when it was sent to us and what I read on the published document on the Inquirer, this is basically a dispute on investments and investment instruments. So, what are investment instruments, Attorney Rodriguez?
As per the law, an investment contract or investment instrument is a contract between two parties wherein one party invests the money in another enterprise with the expectation that the money will earn profit. The one who invests doesn't necessarily need to participate in the business.
In this particular summon, the plaintiff is Primary Land and Primark. And the defendants are the Premier Town Center and SM Investments and Corporate Assets Investments Limited. Can you, based on can you summarize about what the complaint, what the summon is all about?
To summarize, the complaint is about the Primary Land. It's trying to get out of its contract with SM. Initially, as per Primary Land, it became acquainted with SMIC, SM Investments Corporation, through SM Save More, who was leasing one of their stores. Then eventually, they deepened their partnership, and then they primarily then borrows from China Bank. Yeah. Yes, and then what happened, as per the complaint, Primark doesn't want anymore to borrow from China Bank because they are just paying interest. So, they initially planned for an initial public offering, raising something like 1.2 billion pesos through the stock market. However, SM then approached Primark and then said that don't do the IPO yet. We have to make SM a bigger company before proceeding with the IPO. Because according to SM, 1.2 billion pesos is a relatively small amount. So what happened here is SM committed to invest a sum of money to Primark instead of doing an initial public offering, which is a public offering to the stock market. It is a private equity infusion wherein SM supposedly bought shares from Primark, from the entity. Then they did some corporate restructuring, and as per the complaint, it is not actually SM Investments Corporation itself who invested into Primark, but an entity named Corporate Assets Investments Limited, which as per the document is based on British Virgin Islands. And
This is according to the summons.
according to the complaint.
Yeah.
So, SM, through these other entities, the other defendants, they invested 51% share. Initially, the owner of Primark, Mr. Wilbert Tilly, was swayed to enter into that agreement because he was promised that SM will just make an equity infusion but will not interfere in the management operations of Primark. So, as per the complaint, initially that was the setup. However, in the subsequent months, SMIC started putting people into Primark and started interfering in the operations of Primark. And then there was this dispute about the expansion, on how to expand and what next move to make. Actually, the dispute was really between two of the C siblings. If I'm not mistaken, it's Herbert, who operates Save More, and then Harley, who is connected with China Bank. What happened here is that Harley, who was part of China Bank, is telling Primark to raise the rent of SM Save More. However, when Herbert C was asked about it, he does not want the rental to be raised. So what happened here? Because of that disagreement, because the rental, there was a disagreement over that, the funding coming from China Bank was suddenly cut off by Harley C. It was money that were supposedly easily secured from the note facility was not anymore easy to secure, which caused problems with Primark. And they have a lot of problems because of this squabbling between the siblings, that Primark decided not to be out of that agreement with SM. And then Primark dealt with the eldest sibling, Teresita C. And through several negotiations, they were able to arrive at sort of an agreement that there will be a buyback of the 51% equity bought by SM. However, this case was filed because there was also this part of the agreement, as per the Primark, is that aside from buying back the share, they want the notes facility, the credit notes facility, to be waived by China Bank. So Primark can borrow from other banks.
Attorney Rodriguez, aside from that, do you want to add anything more based on what you read on the summons?
Alright, actually this complaint is for reformation of instruments because as I've said earlier, SMIC to Teresita Coson C and Primark through Wilbert Tilly were able to reach an agreement about the buyback of shares. However, as I mentioned earlier, the investment of SM was not made by SM Investments Corporation itself. However, it was made to a certain Corporate Assets Investment Limited and another entity. Those were not reflected in the documents that were supposed to be signed by Primark for the buyback. So, in this particular complaint, Primark is asking that the documents be reflected to reflect the fact that Corporate Assets Investment Limited and the other entity, Premier Town Center Holdings Incorporated, are in fact merely acting as agents of SMIC, who is the real investor between this equity infusion made by SMIC to Primark.
Attorney, what are buyback instruments? From as a layman and as a non-lawyer, it's just a simple definition for me that I was the original owner or the majority shareholder. I want to buy back my majority or the ownership of my company. Is that the same definition for you as a lawyer?
In layman's terms, yes. To put it in another way, buyback is like another transaction. For example, there is a first sale transaction wherein company A purchases equity from company B. And then subsequently, when company B wants to recover those shares from company A, they have to execute another sale transaction, which is company B buying back the shares that it sold to company A.
Does this mean that the new majority owner can refuse absolutely the old owner to buy back his shares or ownership?
It depends on the circumstances. If they're in the original share purchase agreement, there are conditions for the buyback, and if those conditions are met, then the original buyer cannot refuse to sell back the shares. However, if there's no such conditions in the original contract and they have to execute a new set of documents for the buyback, then the other party who initially bought the shares can refuse to sell back the shares under the principle that a contract, there must be consent between both parties when entering into a new contract. By principle, Primark is claiming they agreed in principle on a buyback. They are just discussing certain conditions which, according to Primark, was agreed also in principle, but apparently, SM is saying the other thing.
Any message on how to resolve not only corporate disputes but also personal or civil cases?
Actually, the best way to resolve disputes is, of course, parties should try to talk between themselves. That is the best way, because if they will agree initially, they don't have to go to court and they will agree on a win-win solution. However, if they could not agree between themselves, that's where the court usually comes in. The court acts as a referee and it weighs who between the parties is correct. What I'm trying to say is, you only have to go to litigation if it's absolutely necessary, if you cannot settle amongst yourselves.
And on that note, we end our 6th episode of our talk show here on Advocates Philippines. Attorney Renel, thank you again for appearing in our show. And we will see you on our 7th episode next time. Again, I am Paolo Capino, your host and CEO of Advocates Philippines.